Hi, I'm Denice Gierach. This is part 2 of our series on looking at contracts and 6 things to check in a contract before you sign it. In the first part, we were talking about why it's important to look at some of the details, such as names. Names are important in that contract, and the full names, are the appropriate names, need to be in there. When you sign as an officer of the company, you are signing your name and your title to make sure that you don't have personal liability. So now let's look at the other 5 items in order to have a better feel that when you sign that contract, you're not giving away the store. The first is scope of the work, which needs to be clearly defined. Many business contracts revolve around a performance exchange where an individual or an entity delivers a product, a widget, or a service in exchange for some type of compensation, generally cash. But it could be anything. In these types of contracts where 2 parties are exchanging X for Y, it's imperative that the scope of the work clearly and unambiguously be defined. This is where problems are in contracts. What will specifically be provided in the way of a product or service? Be detailed here. Talk in measurable units, gallons, hours, kilograms, etc., and what's expected in the standards and the grades, the industrial quality, as much as possible. Doing that will reduce any future disagreements and legal disputes. If you run a small marketing firm and you're signing a contract to, let's say, perform specific services like blog writing or social media management, you'll want to be specific in the scope of the work. Clearly state what volume of work, how many blog posts will be written, how many social media accounts will be managed, so that you will have a complete contract. Also, in what time frame that you're going to be doing this, 1 month, 3 months, etc., so that it will be completed in that time frame. If the contract you're reviewing is devoid of key details like these, you're putting yourself and your business an unnecessary risk. There should be a clause for termination in this document, which you need to examine. All business contracts should come with a termination clause of some sort. When you get a new contract to sign, this should be one of the main provisions that you are going to immediately look for and review. What's your way out if it does not work? When does it stop? If your contract doesn't have a termination clause, have one added by your attorney immediately. Why? Because if things start going south in a deal with another company or one of your employees, you need to have a way to get out of that contract quickly and easily and fairly for both sides. In reviewing an existing termination clause, make sure the particulars of that arrangement are, if not favorable, at least not harmful to your company. There shouldn't be anything you disagree with outright. And if there is, you need to bring it to the attention of your company legal counsel, who can work to see that the terms are done in a way that are fair to you and meet with your expectations. Warranties and representations is another thing you have to look at. You must review all representations and warranties. You have to. That are listed in this contract you are about to sign. To be clear, a representation is any action or a conduct that can be turned into a statement or fact. And a warranty is an assurance, promise, or guarantee by one party that a particular statement of fact is true and may be relied upon by the other party. Both definitions, courtesy of the free dictionary out there, in the context of a contract, a representation of or warranty can be given by you or by another party involved if you come across any representations or warranty that is untrue or unclear or is not in your best interest in that contract. You need to consult with your attorney because there's liability there potentially. Remember that any breach of warranty or representation can be grounds for the termination of a contract and can also expose the breaching party to unwanted legal liability. Most, or I guess another one is hold harmless and indemnification clauses. Before you can sign any business contract, you need to examine the language to see if there's either a hold harmless or an indemnification type provision in that contract, as either will expose you to unwanted liability going forward. So you need to read those. Here's how they work. With a hold harmless clause, you essentially rescind your right to seek compensation for things that may go wrong with the contract. That's pretty important, I'd say. Pretend that you run a large supermarket that has a contract with a particular produce supplier. The supplier delivers crates of fresh produce every day, and you pay their invoices on receipt. Simple enough in that situation, right? What can go wrong? Well, pretend one day all the workers at the produce supplier go on strike. The strike lasts for 3 weeks, and you can't get the distributor to deliver so much as an apple, or a pear to your store during that time frame, costing you tens of thousands of dollars of lost business. As a result, you ask your attorney to file a lawsuit seeking damages from the distributor as a result of their actions or inactions. If in reviewing your contract, your attorney discovers you signed a hold harmless clause where you waived your right to sue the supplier for failure to deliver produce due to labor-related issues, your attorney is going to say, sorry, but we can't do anything. That's not a good situation to be in. Now, an indemnification is similar but not identical. With an indemnification provision, you are volunteering to protect another party from any liability or loss that they may have that arises out of the performance of your contract. For example, picture yourself as the owner of a large media company. You hire a journalist to write a series of scathing articles about the behavior and practices of Warren Buffett, let's say. He's a public figure. These articles will then be published by your national magazine. In a few weeks, these articles are written, published, and pushed into circulation. Warren Buffett picks up one of your magazines, and there it is, and he doesn't like what he sees. What a surprise. He decides to sue you and the journalist, for defamation, which he would have the right to. However, your journalist had induced you to put an indemnification clause in the hiring agreement. A clause like that states that you, as the owner of that media company, will protect the journalist from any liability that may arise from the writing of those articles about Warren Buffett. What does that mean? That means you are on the hook for both lawsuits, the one that names you explicitly and the one that names the journalist as well. Compensation structure is another item that has to be looked at carefully. At the end of the day, it's all about the money, right? What compensation are you getting? For that reason, every contract you start with has to have that financial transaction, that financial piece in it, and should be clearly defined. So the structure of that compensation is important, so that there's no debate about how much money should be paid during the course of that contract, when it needs to be paid or who it needs to be paid to. If you've expressed certain wishes regarding compensation, for example, that you only want to accept payment via credit card, or that you only want to pay your contractor once every 90 days, those wishes should be noted. If they're missing, you need to go and see that they are included in that contract. Otherwise, they will not carry the day, nor will they be enforceable. A final thought is, while you hopefully are found the information in this two-part series to be helpful, there's no way to know exactly what's inside of a contract other than by reading it line to line. It's the only way in reading that contract that you're going to know and have a comfort level that the decisions you're making, that you're including in this contract, are going to promote and be viable for your business. So in terms of looking at this contract, if you're not going to do it, you need to consider taking this to your counsel and investing the money in making sure that this is the contract for you. This is going to save you money in the long run. So don't look at it as a cost, look at it as an investment. We hope that you have enjoyed this two-part series on what to look at when you're looking at a contract that's put in front of you. And we hope that we'll see you on other types of information videos that we put out there. If you would like further information, please call us at the number below the video, and I'll make you an offer. If you want us to look at something or give you some advice on something as a result of your looking at our videos, we'll give you a 15-minute consultation for free over the phone. So feel free to dial up that number, and we'll be looking for you then. Take care.